Hi, it's Ron Coleman. Welcome back to Law Learning. We talked about the constitutional and historical bases for the civil litigation system and the structure of the courts in the United States: state courts, federal courts, appellate courts, trial courts. Why do people go to courts in the first place? We addressed that somewhat in Chapter 3, Lesson 3, where we talked about the difference between criminal and civil litigation. We're going to put criminal aside for the foreseeable future and talk about what it is that gets people into court on a civil dispute. That means that there is no government, or at least penal aspect to it. Government can, again, be a party to a civil lawsuit. Sometimes on Twitter, you probably know that I am on Twitter. Sometimes on Twitter, people hear about a case or a potential case or a dispute or a violation of rights or some outrage, and they think this would be a great case for Ron Coleman. So you have to understand something. We are allowed to advertise. There was a time when lawyers were not allowed to advertise. That was considered to be unprofessional. But the Supreme Court held that it was unconstitutional for state bars, attorney advertising, although it could regulate it, but it could not prohibit it outright. So, what you don't want to do, both ethically and as just a matter of personal, professional dignity, is either be a lawyer who files cases and looks for clients, or be a lawyer who runs after clients, encouraging them to file cases. There are exceptions to that. There are causes, there are outrages that do come to our attention, especially if, like in our law firm, you have a close relationship with a nonprofit organization that funds legitimate lawsuits. So then we might decide that this is an issue we would be interested in litigating if there is a plaintiff. But we don't, as a general rule, start lawsuits. People start lawsuits or companies start lawsuits. We represent them. The best situation when that happens, from our point of view, is when a person who can afford our services contacts us and says, I have a legal problem. And from what I understand, you might be the kind of lawyer who can help me solve it. A lot of people want to know whether they can bring a class action in order to solve what they correctly perceive as a very widespread form of harm that's being done by one party, such as a social media platform or the government, perhaps by censorship or by any number of things that seem, again, to affect a lot of people. Often it's politically oriented questions, and that's part of the answer. The fact that it's often political or ideological, that's part of the reason why the answer is almost always going to be no. Class actions have to be premised on a class existing where the harm suffered is common among all the plaintiffs or the members of the class in both legal and factual ways. If your account was banned, the way you've been harmed is different from the way everyone else has been harmed. That's not going to be a class action. Our firm has a very narrow focus. We're business litigators. We do a lot of civil rights work. We do a lot of free speech work, social media related stuff, but we don't do pension litigation, securities litigation, personal injury litigation. There are exceptional cases, but by and large, we do what we do and we don't do things that we don't do. That doesn't mean you shouldn't give me a call if you've got something, because I probably can find you the right person almost in any state in the United States. And as a general rule, that doesn't benefit me in any way financially. There are exceptions to that, especially when it comes to personal injury referrals. Certainly the state where I practice, where my office is located in New Jersey, you are allowed to get a referral fee for a personal injury matter. It's not something that happens too often in my life. Depending on the circumstances and the relationship, we will either discuss it with them for no fee or charge a consulting fee, because our time would be wasted by a lot of people looking for free advice who are calling 4, 5, 6 lawyers. Sometimes that makes sense, but sometimes it doesn't make sense. Sometimes you end up giving away the store for free. It is a pretty common thing for us to find that what is being described is not a problem that can be rectified through the courts. This is a huge issue. Technically speaking, there is a concept called justiciability. Can it be rectified through the use of the courts? There are a lot of legal sounding issues or things that involve the way courts work, the way governments work, that actually don't belong in the courts and that the courts have no authority over. Even in a more general sense, there is the kind of thing that, because of the way specific laws work, you really can't do anything about. This most commonly happens in the area of defamation. People can say things about you that are hurtful, hateful, even harmful without their being defamatory. Defamation requires a knowing or negligent, or in the case of a public figure, you've heard this phrase, right? False and harmful light that causes damage. That's a very broad definition. Most of the things that people ask us about as potential defamation claims are not really defamation claims. One of the most famous examples of a defamation claim that has nothing to do with defamation is one that Alex Jones was subjected to. That's entitled to its own video. Perhaps by the time you see this video, that verdict will be overturned. That was a travesty. Saying things that hurt people's feelings, make people feel bad, make other people angry at you and dislike you and even threaten you is not defamation. Defamation is a false statement that causes harm. There's another issue. They claim that you were convicted of a crime, but you weren't. They claim that you're a sexual predator, but you're not. We're not even coming onto the zone of opinion. Let's just keep it simple here because we're still early on in our lessons. Let's say that in our consultation, you satisfy me that a false statement was made about you that causes harm to your reputation and that you've even suffered damages because of it. Because let's say you were fired from your job or not hired from a job that you wanted to have. So that would not only be damages, but damages that can actually be quantified. I was making $75,000 and then I got fired. Now I'm making $50,000 doing something less. There's $25,000 in damages. If I can prove that the defamation caused the loss, we have a prima facie case. What does prima facie mean? Even when I have that, and that's pretty much the best case scenario, and it's hardly ever what we have. Even when we have that, it still might not pay for you to bring a defamation action for at least two reasons. Succeeding on a defamation action could very well cost you more than $100,000, depending on the defendant and many other factors. We'll talk about motions to dismiss. There will be all kinds of cost inducing activities in the lawsuit. It might cost you more to litigate than you would make in recovering damages. Most circumstances, each party pays for its own legal fees. Winning a lawsuit doesn't get you attorney's fees unless a statute specifically provides for it. For example, in the case of copyright infringement, if I win a copyright infringement lawsuit against you, the court has discretion to award attorney's fees. And in other statutes, there's no discretion at all. The court has to award attorney's fees. Keep in mind, the defendant may not have the money either to pay the judgment or to pay the attorney's fees, much less both. So let's say I win. I take on your case, I win, and you spend $200,000 getting to that win. So you get an award of $200,000, and you get $200,000 in attorney's fees. You now have a judgment for $400,000. The person that we succeeded in getting that judgment against.
First off, I am 35 years old. I am divorced, and I live in a van down by the river.
What have you accomplished? Well, if you're an extremely wealthy person to whom money means nothing, you can show off to your friends that you have a $400,000 judgment against this person who lives in a van down by the river. But it's not particularly cost effective. But there's another very important reason. Every time some reporter reports on, or some blogger blogs on, or some tweeter tweets on your lawsuit, you're repeating the association of yourself with the defamatory claim. This is called the Streisand effect, where you make the mistake of using a legal threat to prevent something from happening, and it ends up becoming worse off for you than if you had not made the threat. The Streisand effect happened when Barbra Streisand sued a photographer and a website claiming a violation of her privacy for publishing a photograph that included her home, a picture taken from the air, which anyone has a right to do, in a collection of 12,000 photographs of coastal erosion in California. She wanted $50 million. What she got was her lawsuit thrown out on its ear. And that picture became world famous. Everybody published it. More and more people than ever went to see what it was that Barbara wanted so desperately no one to see. That's what the Streisand effect is. You may win and you may even collect your judgment, but you may also cement that public perception and the public association between you and the defamatory claim about you in a way that never would have happened in the first place. So we often counsel watchful waiting in the case of defamation clients. In fact, I sometimes refer people to reputation management companies because what they really need is help with their SEO. You can do something about Google results. There's lots of ways to change your search engine optimization results and to generate content that pushes the bad content off the front page. Now, it's also true that to some extent, that's what corporate media does to its friends. Google, in particular, will protect its political friends by changing search engine results. Facebook does this too. All the major search engines do. Nonetheless, it's an option that is often more rational and more cost effective than spending money on lawyers. I'm just using defamation as an example, but as a general principle, I'm not doing my job if I don't spend a good amount of time walking with you through the process of avoiding filing a lawsuit. Now, this is different, of course, someone calls me and says, I've been sued. Then I can have a comparable discussion about what can we do to get rid of the lawsuit, short of defending it. Maybe someone just needs a retraction, an apology, or some reasonable settlement. If they don't, then we have to defend the lawsuit. Can we avoid it? Can we get your goal accomplished or something reasonably close to your goal without spending money that you're going to begin resenting sooner or later when you don't get exactly the result you want, or the result you want as fast as you like, or when my explanations of why a judge did something or my inability to explain why a judge did something, which sometimes just do whatever they want. My job is to avoid taking you on as a client, not because of you, not because of me, but because litigation is an extremely expensive, wasteful process that very frequently causes more harm than good to the party that begins it. We'll talk a little bit more about what happens if we get past that stage in our initial consultation in lesson 5. Happy New Year, everyone.